Good afternoon. I'd like to welcome you to Rescheduling Implications for Los Angeles Operators, hosted by the City of Los Angeles's Department of Cannabis Regulation. My name is Angela Baca, and I'm the Director of Academics at Oaksterdam University, the first and longest running training for the cannabis industry in the world. I'm excited to be your moderator today. We are here because the Department of Cannabis Regulation has provided the Business Licensing and Compliance Assistance, or BLC, program to assist equity entrepreneurs in the City of Los Angeles with obtaining a commercial cannabis license and operating a successful cannabis business. Please visit cannabis.lacity.gov for more announcements on the ever-improving BLC program and for live webinars with different subject matter experts, checklists, worksheets, and other management tools you can download and use, links for accessing expert consultants in the BLC coaching program that connect applicants with seasoned cannabis subject matter experts. And we'll be dropping the link in the chat right now for you to sign up for these coaching services. You'll also find self-directed online education on important topics related to running a successful cannabis business through the BLC's Learning Management System, which is also referred to as the LMS. As part of the city's social equity program, DCR has launched its BLC LMS portal where you can access recorded webinars, online courses, and digital resources made especially for social equity applicants and licensees. I highly recommend that you take this course and explore the LMS if you have not done so already. Before we get started, let's take a moment to review some housekeeping rules. Please note that this webinar is being recorded and can be viewed after the editing process on the DCR's website in the LMS I just mentioned. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available during this session. However, you will be able to see and hear all the experts. Please ask questions about today's subject in the Q&A box. We are gathering and responding your questions through the presentation, and we'll have a dedicated Q&A session in the last 30 minutes of today's event. You're encouraged to utilize the Q&A box at the bottom panel of your Zoom screen. If you're using the Q&A box for questions, everyone can see the answers to your questions. And if you do have a question, many other folks likely do too. Finally, please note that today's content was not created by the Department of Cannabis Regulation or the City of Los Angeles and is for informational purposes only. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code nor constitute legal advice. If you have specific questions outside of today's topic, please call 213-978-0738 during business hours, Monday through Thursday, 10 a.m. to 4 p.m. to speak to a DCR representative. Now it's my esteemed pleasure to introduce you to today's subject matter expert, Dale Sky Jones. Dale Sky Jones started her career in hospitality and retail, working her way up as a corporate trainer, new store opener, general and district manager, broadline distributor, and was a small business owner and successful restaurant in California. Dale moved to Southern California to manage a small group of doctors in Southern California, working with medical cannabis patients. Today, Dale is the Chancellor and Executive CEO of Oaksterdam University. Let's go ahead and hand it over to you, Dale.
Thank you so much, Angela. I appreciate it, and it's really great to be here with you all today. All right, first and foremost, let's separate fact from fiction and understand what is really going on here with respect to the Schedule 3 announcements that have taken up the news as of late. This is a very complicated topic because it involves a lot of speculation. However, you don't have to take my word for it. The information used to develop today's webinar came from an important resource you need to be aware of. It's called the Congressional Research Report, the CRP, prepared by the Congressional Research Service, the CRS. The CRS serves as a nonpartisan shared staff for congressional committees and different members of Congress. They basically provide the information by which members of Congress are going to make their decisions, form their policy, and eventually, hopefully, get the chance to vote on it. The link that Angela will be dropping in chat will also take you to other resources direct from Congress surrounding the topics we are discussing today. So if you want to go deeper on anything that you hear me say, or keep tabs for yourself on the new developments, please do follow the Congressional Research Reports. There's also a wealth of links for you to follow additional information on everything from hemp to FDA, what is the DEA doing anyway, all sorts of different reports details and additional information so that you can separate for yourself fact from fiction and bridge to the source. Also, some of the commentary on the actions that you might take as both a citizen, a voter, as well as a small business owner, which also has its own power. These are my own commentary and recommendations based on nearly 20 years of successful and unsuccessful policy actions, what works and what doesn't. So first, we'll make sure that we understand the ramifications of Schedule 1 and Schedule 3 under the Controlled Substances Act of 1970. Then we'll cover rescheduling announcement recently by President Trump, what that means for you, especially with regard to banking and federal taxes. We'll also discuss what changes Schedule 3 may bring, including the announcement on reimbursements for up to $500 for medical cannabis patients for hemp-derived full-spectrum cannabinoids, and how you might even qualify to participate in that at some point. And we need to work on that lobbying quickly. California hemp law does need some advocacy. It does allow for hemp-derived full-spectrum cannabinoids to be manufactured and sold by legal cannabis businesses, but we're going to talk about some of those limitations and what it will take as well for your products to potentially pass into the FDA approval system, or at least approval for reimbursement, which may in fact be two different systems. We have a window here. I will also break down GMP and GACP. We touched on those in the last webinar. This is good manufacturing practice and good agricultural and collection practices. GMP, good manufacturing practice, covers the post-harvest processing, extraction, and packaging stages, post-harvest to distribution, which is most of you. This also, GMP, covers treating the product like a pharmaceutical. GACP, good agricultural and collection practices, are what you need to make sure that folks within your supply chain are doing. That covers the cultivation and harvesting stages from seed to harvest, focusing on the growing conditions, soil, and preventing contamination. You also may hear sometimes thrown around a few other sets of acronyms, specifically in this case, EU GACP. The EU is just referring to the European Union standards version, which is important because that is the international trade that you want to eventually get into. Critical for participating beyond the state market, and a minimum for that international trade, and eventually, potentially, let's hope, interstate commerce. It's kind of weird to think that in some ways international trade may be defined before interstate. But that's where we are. So congressional and lobby actions as well that you might be able to take, and in some cases under 10 minutes, to help move this into a better direction for you, for state legal adult use equity cannabis businesses like yourself. You do have strength in numbers, and you can push back on large lobby dollars with large voter numbers, lots of phone calls, lots of action, strength in numbers. The one thing that trumps money is votes. Now, when you hear me say CSA, I mean the Controlled Substances Act. I'll try to keep the acronyms to a minimum. That is not the same thing as the CRS. That is the Congressional Research Service. So the CRS does the reports. The Controlled Substances Act is what we have all been living under for quite a while. And so you're thinking, I know what Schedule 1 is. Well, of course you do. We have been basically figuring out how to set up our businesses to circumvent, to ignore, to break that one law around Schedule 1 with marijuana. And you're going to hear me refer to marijuana a few times in here, and that is the way the original law in the CSA refers to what is scientifically known as cannabis. And so generally, I split it by the failed marijuana policies versus the new cannabis policy reforms. So in 1970, Congress passed the Controlled Substances Act, which was signed into law by then President Richard Nixon, and that law established 5 schedules to rank regulated substances deemed to have the potential to cause harm or lead to addiction. The CSA restricts the production, sale, and possession of these scheduled substances and establishes criminal penalties for violating them. Those restrictions and penalties increase as you go up the schedule towards Schedule 1. So penalties are most severe for the drugs listed as Schedule 1. Marijuana, with an H, is currently listed as Schedule 1 along with heroin, and drugs on Schedule 1 are considered to have no medical value with a high potential for abuse. In April 2024, it was first announced that the DEA would be moving marijuana from Schedule 1 to Schedule 3, and the Congressional Research Report was released first May 1st in 2024. This is what has provided the insight as to what to expect and what has been summarized throughout the webinar. It has been updated with additional reports, but by and large, nothing has changed. The CSA included the factors which must be considered when determining how a particular drug should be scheduled. Now, back in the day, it was political. There are two key factors that must be weighed when the drug's both actual or relative potential for abuse and the scientific evidence of its pharmacological effect, including any known therapeutic benefits. We have shown over and over with research that it is at least as effective as many drugs that are commonly prescribed. It, in fact, has more research than many drugs commonly prescribed. However, cannabis, despite the proven medicinal benefits, and this is not, again, my word for it. We're going to talk about a couple times, including the original Schaefer Commission report, which really indicated that it never should have been Schedule 1 in the first place. That was in 1972. And then in 1988, under the Bush Senior administration, there was another review and ruling by the administrative law judge, Francis Young. He was the chief administrative law judge at the time for the U.S. Drug Enforcement Agency, the DEA. And as part of his ruling in the case of marijuana rescheduling, docket 86-22 said marijuana in its natural form is one of the safest therapeutically active substances known to man. And so we're going to talk more about administrative law judges soon because they play a very big part in the rescheduling process. But you might note 1988, they can also be entirely ignored. So here we are, 56 years later, in front of another administrative law judge who last year retired. Again, nothing continued to happen. So make no mistake, these decisions have not been scientific. They have largely been political and administrative. However, that is a different history and policy class. And so I'm only trying to explain enough to give you the context for where we are now and also what may happen or what may continue to fail to happen more accurately so far. Now, Schedule 1 drugs, as you know, cannot be prescribed. Medical cannabis is recommended. Schedule 3 drugs must be prescribed. Doctors are allowed to prescribe controlled substances, and any item, any substance that is listed, Schedule 2 through 5, a doctor can prescribe. But it is considered, if you are on a schedule, Schedule 1 through 5, you are a scheduled drug. And so you must register as a doctor with the Drug Enforcement Administration in order to prescribe these drugs, which is why it's so dangerous for a doctor to step out of line. If they lose their ability to prescribe drugs, they're not a very effective doctor. And so this has been historically what has scared a lot of mainstream doctors away, in addition to the stigma, is the harassment. So historically, doctors in states where cannabis has been legalized for medical use have issued formal recommendations. This is in place of a prescription, which they are not allowed to do on a Schedule 1 drug. So you know this. We're flipping it around now to talk about Schedule 3. So patients will need a doctor's visit for a prescription. A recommendation will not suffice to qualify a person for reimbursement under the current interpretation of what just happened. Remember, there is no medical defense for violations of the Controlled Substances Act. The federal government considers the uncontrolled production and possession of all scheduled drugs a federal crime. So, this flip of the switch with Schedule 3, when it happens, first off, is not a single switch. It's hundreds, if not thousands, of individual decisions and rulemaking processes, all of which have different opportunities to get slowed down or stopped. But it's not an automatic, you may pass go if you are even just handling medical cannabis in California. So, listing marijuana as a Schedule 1 has also severely restricted opportunities for scientific research on the plant's therapeutic uses. So, we're going to make illegal the ability to identify the therapeutic uses that we are demanding to prove that it can be used medicinally. Any research institution that wants to perform cannabis research must first find the funding and then undergo an extensive review process that can involve multiple federal agencies, not just the DEA. Researchers also face a significant challenge in securing quality cannabis to use in their research. For over 50 years now, the only site, and that's the University of Mississippi, only they had federal approval to produce cannabis for research purposes. And so scientists were very limited to what they could acquire from this single cultivation site. Also, the quality and the potency were, truly terrible. If you saw the tin of medicine, of which I have for more than one patient, it is shameful what they're handing these IND patients, the federal patients. It is often moldy, it is always years old, and it sticks and seeds and stems. It's not great. They have to break open the pre-rolled cannabis joints and then clean out all the stems and seeds and then re-roll it in order to have a halfway decent experience. What this will hopefully do, because that material is not diverse at all, and like I said, it's truly terrible. It does not compare to what we sell in your dispensary or the products that you sell by any stretch. In 2021, the federal government did open the process for more research institutions, but it's still been very difficult, and very few have progressed to an actual research stage. When cannabis is moved to Schedule 3, in theory, more research can be conducted. Even then, it's promising to not be as extensive as if it were descheduled. According to the Congressional Research Report regarding rescheduling, the DEA is required to set annual production quotas for Schedule 1 controlled substances manufactured for use in approved research. The DEA is not required to set annual production quotas for Schedule 3 controlled substances. So the good news is we'll be able to do better research with better cannabis and probably get better results. So cannabis and its derivatives generally fall within one of two categories under federal law. And just to be clear, cannabis, hemp, marijuana, one species. It's the same plant, one plant. Botanically, the same plant. There are different varietals, different chemotypes, different phenotypes, just how people look different. They have different color hair, different color skin, different color eyes, different shaped faces, but we're all Homo sapiens. We're all the same species. Well, so is the cannabis plant, which includes hemp and what they call marijuana. So cannabis and its derivatives, it is just the law that differentiates this species based on the THC content when it is grown. Unless an exception applies, the Controlled Substances Act classifies the cannabis plant and its derivatives as marijuana. There are some provisions in statute that include an H, some with a J. The CSA, the Controlled Substances Act definition of marijuana excludes products that meet the legal definition of hemp, and two, the mature stalks of the cannabis plant, the sterilized seeds of the plant, the fibers, oils, and other products made from stalks and seeds only. Marijuana is a Schedule 1 controlled substance under the Controlled Substances Act. Currently, applicable federal law defines hemp as the cannabis plant or any part of that plant with delta 9 tetrahydrocannabinol, THC, that concentration of no more than 0.3%. In November 2025, Congress enacted legislation changing the definition of hemp so that, among other things, it is now defined based on total THC concentration rather than just the concentration of delta 9 THC. That new definition is scheduled to take effect November 2026. So, wow, just like 9 months from now. Now, hemp is not a controlled substance under the Controlled Substances Act. It was descheduled and is regulated by the USDA for the most part. So, while the 2018 Farm Bill removed hemp from the Controlled Substances Act, descheduled, delisted, unscheduled, there's lots of words you could use, it explicitly does preserve the FDA's authority to regulate any of those products under the Federal Food, Drug, and Cosmetic Act. So currently the FDA maintains it is illegal to market CBD by adding it to food or labeling it as a dietary supplement because the FDA retains authority over hemp-derived products intended for human consumption. So CBD food, drinks, supplements. Other congressional report products also talk about the legal and policy implications of that change, the non-psychoactive compound CBD, cannabidiol, that falls within the legal definition of hemp. So when you hear hemp-derived cannabinoids, this is often what we're talking about. All right, so who has the power? Who has the power? All right, the presidential powers to change cannabis law. Well, the president doesn't actually have the power. They cannot directly change the status of marijuana under the federal controlled substances law, but can direct executive agencies to consider rescheduling marijuana, as President Trump did in December 2025 in that executive order that just made quite a bit of hoopla. The Controlled Substances Act does not grant the president a direct role in the classification of substances, so he can't just stroke of the pen say it is Schedule 1 now. However, the CSA empowers the Attorney General, who delegates this to the DEA. So it's just more likely to move forward under the Trump administration because there is a permission structure under that power structure between the president and the Attorney General, Pam Bondi. To make these scheduling decisions. Now, the DEA is who actually does this through a formal notice and comment rulemaking process. So the DEA is legally bound by the medical and scientific recommendations of the Health and Human Services Department and the Food and Drug Administration. So both HHS and FDA have to be involved. This includes the Administrative Procedure Act, the APA, which requires reasoned explanation and consideration of public comments to avoid being overturned by the courts. So if they go through that process, it is more likely to withstand lawsuits. Now, they can point to international treaties. The U.S. is a signatory to the Single Convention on Narcotic Drugs, which the DEA also is supposed to consider when making domestic controls. Please keep in mind that the U.S. basically determined what the world policy was in the first place and demanded other countries adopt our failed policy of prohibition in the first place. Also, we regularly ignore international treaties, and not just under this administration. We kind of do what we want. We're America. So, President Trump's December 2025 executive order functions as that formal directive to these agencies to, and this is per the EO, the executive order, to expedite and take all necessary steps to complete the move to Schedule 3. It is not an immediate legal reclassification. I saw a lot of articles that were like, it's Schedule 3 now. No, it is not. No. It was just a directive saying you need to do this, just like the last directive under President Biden. The executive branch functions to execute laws that Congress enacts. Congress writes the laws. The executive branch executes the laws. Congress must be more functional in order to act. But this is really the power of Congress. And so, unlike the executive branch, which must follow the rigorous administrative process that I just described or started to outline, including all these hearings and scientific review, it's Congress that holds the ultimate authority. So Congress can amend the Controlled Substances Act directly through legislation to reschedule, deschedule, or create an entirely new category for cannabis without any input from the DEA or Health and Human Services. Congress originally placed marijuana in Schedule 1 via legislation in 1970 and has since used its power to schedule other substances like synthetic cannabinoids. Now, synthetic cannabinoids like bath salts, synthetic cathinones, these are not, like bath salts are not synthetic cannabis, as in it's just like cannabis. It's that it interacts with the cannabinoid receptors in the human body. As part of the Synthetic Drug Abuse Prevention Act, so bath salts was 2012, Congress also permanently moved MDPV and 9 other synthetic stimulants into Schedule 1, along with anabolic steroids, which were placed into Schedule 3 in 1990, and GHB, the date rape drug, in 2000, though that particular act did separate out the GHB into Schedule 1. The stuff that somebody slips a Mickey into somebody's drink is Schedule 1, but also simultaneously allowed for a specific medical version that is in Schedule 3 that turns out treats narcolepsy. And so I'm mentioning this because I just want you to point out that sometimes the same substance is treated differently depending on if it follows a certain manufacturing and sales pathway, the FDA through a pharmaceutical with a prescription versus what they would call street drugs. We saw a similar comment by President Trump around fentanyl and the difference between street fentanyl and medicinal. It does have a time and place, usually in surgery, but definitely under the supervision of a doctor. So Congress uses its powers to remove or exclude substances from the Controlled Substances Act all the time. And the big one, lest we forget, is hemp in 2018. It really started in 2014, but fully 2018 Farm Bill legislatively removed hemp, defined as cannabis with below 0.3% THC, from the definition of marijuana and thus from the Controlled Substances Act entirely. Fun fact, alcohol and tobacco are explicitly excluded from the scope of the Controlled Substances Act by statute by Congress. Food for thought. Hey, can anyone hear me? Hey, Congress. Yeah. Do you know that you have 3 congressional representatives in 6 offices because you have 2 representatives and a senator, and they have offices in DC and in California? So 2 senators plus a congressperson. Each call takes about 2 minutes, and you can look up and knock out 6 calls in under 10 minutes with all of them. Congress.gov. Congress.gov. Just click the link. You can find your reps and give them a quick phone call and explain to them that Congress has the power to remove or exclude substances from the Controlled Substances Act, and we can treat this more intelligently as one plant. So, if you are feeling some deja vu, you are correct. This was exactly the same announcement that Biden made in April of 2024 to direct the DEA to look into rescheduling cannabis. The next steps in the rescheduling process were the DEA conducted its own review and did start that process. Now, the review of marijuana was a test it established back in 1992 that examines the drug's chemistry, safety, and scientific evidence. This is known as currently accepted medical use. So all drugs must pass this. If the DEA opts to move forward with rescheduling marijuana to Schedule 3, it would do so through the rulemaking process. Now, per this report, those authors are unaware of any instance where the DEA, and this is the Congressional Research Services, unaware of any instance where the DEA rejected an FDA recommendation to reschedule. So the DEA, one federal agency, tends to listen to other federal agencies, usually. As a comparative example, in 98, the FDA recommended that Marinol be rescheduled. And Marinol is dronabinol. It is synthetic THC. It is pure 100% THC, but created synthetically. So Marinol was rescheduled in July of 1999. So if you didn't hear that, pure THC, not naturally grown, but the chemical identical substance, dronabinol, on the market as Marinol, 100% THC, is already Schedule 3 pharmaceutically. Yeah. So let's see, where was I in history? January 2025, President Trump took office. Biden's policy immediately got shelved. And then in December of 2025, on the 18th to be exact, President Trump issued that executive order that I mentioned, directing the Attorney General to take all necessary steps to expeditiously move marijuana from Schedule 1 to Schedule 3 under the Controlled Substances Act. That's a quote. The executive order followed the May 2024 notice of proposed rulemaking from the DOJ, the Department of Justice, and the DEA, proposing to reschedule marijuana from Schedule 1 to Schedule 3, because a lot of this had already started, but at the time that the executive order was issued, the agencies had not yet taken any final action on that proposed rescheduling from the last administration. So we are still waiting to see what and whether and when they will do so. And this is where it also gets a little bit tricky and stalled. Terrence C. Cole, is the recently installed administrator of the U.S. Drug Enforcement Administration, otherwise known as the Drug Czar, as of July of 2025. Now, during his confirmation, he stated that reviewing this rescheduling process would be one of his first priorities. The DEA publicly, however, clarified that despite the executive order and his statements in his hearing, the matter must still complete required administrative steps before a final rule is legally effective, and the process remains frozen as well, pending the resolution of multiple legal appeals. The potential use of expedited statutory pathways are still on deck, but the current drug czar's official strategic priorities have really just been focused around dismantling drug cartels and combating the fentanyl crisis, not so much on cannabis policy reform. The process is still stuck because the DEA is caught between conflicting legal obligations, the mandate to follow the Administrative Procedure Act, the APA, which requires fair and transparent hearings. Part of the question is will they include some of the hearings that have already happened, although some of those hearings were canceled. And the Administrative Procedure Act requires these fair and transparent hearings to occur. So President Trump has an executive order saying hurry the hell up, but the DEA is stuck in its own bureaucracy. So the DOJ is exploring some pathways to bypass the administrative hearing process. There is something referred to as the Epidiolex method. Epidiolex is it's referred to as the fast track. It in of itself is a drug that has been on the market for a while. It would allow the Attorney General to bypass the standard hearings if that rescheduling action is required to meet international treaty obligations, that Single Convention on Narcotic Drugs, citing the need for international compliance alongside the Health and Human Services scientific findings, the DOJ could theoretically issue a final order immediately and skip months of these hearings. The other hurdle, there was a judicial vacancy. So we keep talking about administrative law judges. The chief ALJ, who was overseeing the rescheduling record, John Mulrooney, retired in July of 2025. And that left the DEA without a presiding judge to manage a mountain of scientific evidence and over 43,000 public comments. So once the hearings eventually resume, there is a lot to go through if they resume. There's also a litigation risk because, as I mentioned before, if the DEA uses this expedited pathway and just skips some of these hearings, it does risk being sued for violating the APA. And I promise there are prohibitionists, specifically with SAM, Smart Approaches to Marijuana, leading the charge to make sure that it is as held up as possible and all the lawsuits fly. So any final rule issued under executive pressure without a reasoned explanation that addresses all these significant public comments is going to be highly vulnerable to being overturned by federal courts. The other and maybe primary reason for the current standstill is also an interlocutory appeal. Now, this is a legal challenge that is filed before a case is finished, and that has stayed all administrative proceedings since January of 2025. If you're curious, there are allegations of bias. Pro-reform advocates like Village Farms and Hemp for Victory moved to disqualify the DEA from overseeing this process, alleging that that agency is biased. There is some evidence of that. Advocates point to the cure letters sent by the DEA to help anti-rescheduling groups qualify for the hearings while systematically excluding all but one pro-reform voice, that would be the NCIA, and state-level experts like those from Colorado. Until the DEA Administrator Terry Cole rules on this appeal, the administrative law judge cannot resume hearings. And so as of yesterday, no briefings have been scheduled and nothing has been set. Friendly reminder, direct congressional action. So this isn't an executive pathway, but the Congressional Research Service has also noted that Congress can enact rescheduling or descheduling via legislation at any time, which would legally override all of this, the current administrative and judicial gridlock entirely. So, what is shifting? Well, everything, and a lot remains undecided. But the silver lining here is the future is still shapeable because they don't know what they're doing either. And there are so many competing interests already lobbying for their place in space. We can do the same. And there are many more small businesses. Small business is the backbone of the American economy, and there is no difference in the cannabis economy. We have to push for this. So those who manufacture, distribute, dispense, or possess medical cannabis may soon be able to do so lawfully under the Controlled Substances Act by following the FDA regulatory pathways. States' medical cannabis programs may now be able to comply with the CSA and will still be subject to CSA and DEA criminal and regulatory control. Federal public health laws, such as the Federal Food, Drug, and Cosmetics Act, as well as the agricultural laws, such as the Agricultural Marketing Act of 1946. Now, while rescheduling signifies that the federal government recognizes marijuana as an accepted medical use, it does not legalize the current state-regulated market, which still operates outside of federal FDA-approved channels. And so California law isn't going to completely automatically comply, although with the recent law at the end of last year, the hemp ban, we'll talk about that briefly in a moment, the FDA approval is required. The bottom line here is Schedule III substances must be approved by the Food and Drug Administration to be legally dispensed. So botanical flowers, vapes, edibles, all of the normal products that are currently sold in California dispensaries are not FDA approved. We're also talking about prescription versus recommendation. As I mentioned earlier, Schedule 3 drugs must be dispensed via a valid prescription from a DEA registered practitioner, not a recommendation, a prescription. Also, there is a closed system conflict. The CSA requires really strict DEA registration for manufacturers and distributors. And state licensed operators in California, as far as I know, there may be one or two, but generally they're not currently registered with the DEA. So the scope of and demand for FDA oversight for medical cannabis and related products will grow considerably, and the FDA will need to generate and update a huge amount of technical information to clarify its regulatory approach. And this is the FDA. They are an under-resourced agency at best. All right, so we talked about researchers who hopefully will face less strict regulatory controls in researching cannabis as Schedule 3 controlled substance, which may in turn promote and allow for further research on cannabis. The DEA will no longer set production quotas on limitations for cannabis for Schedule 3, and those who use medical cannabis lawfully may contend with fewer barriers to federal employment and eligibility to serve in the military. One other thing to note is the producers of dronabinol lobbied to be allowed to extract THC versus synthesize it because it's cheaper and easier. And so I do see that shift potentially happening, that something that used to be synthetically created now is grown and derived. Let's hope. Also for our veterans to have access to medicine that helps them is long overdue. So federal statute specific to the criminal prosecution and or trafficking of marijuana per se would not be automatically changed by rescheduling, because these statutes and the penalties provided in these statutes are not directly tied to cannabis's scheduling. Amending these statutory penalties would require an act of Congress. By contrast, there are many federal laws that penalize activities related to the use of any Schedule 1 substance. These include the federal prohibitions on your ability to possess, purchase, firearms specifically, that's back in the news again. Also, things like residing in federal or subsidized housing. Moving cannabis to Schedule 3 may provide a legal basis for successful challenges to these and other similar federal restrictions that are contingent upon Schedule 1 status. And of course, there's the big one. Would rescheduling modify tax policies for state licensed cannabis businesses? Now, the big goal here is for cannabis producers and retailers to be able to deduct the costs around selling their product, payroll, rent, advertising, training, normal business deductions that every other business in America is allowed to take for the purpose of their federal income tax filings. So in theory, reclassifying cannabis to Schedule 3 would arguably permit state licensed businesses for the first time to take traditional tax deductions because they will no longer be providing services specific to a Schedule 1 federally prohibited substance. It is also possible that banks and financial institutions may be more willing to partner with businesses such as yours post rescheduling. However, there are further statutory changes that will still be required by Congress, including potentially the passage of the Safer Banking Act to codify these relationships. And it's still likely that larger institutions continue to not provide services for the cannabis industry as long as cannabis remains scheduled. And oftentimes it's the smaller companies, and it's really about debanking. The larger companies do have quiet banking relationships. Now, Trump issued an executive order in August removing the reputational risk standard, which is what, if you've heard of Operation Choke Point, it's what Operation Choke Point relied on. This was used by both the Obama administration and Biden administration. So we are not out of the woods yet, but that was an important move. Also, the Cato Institute, which is a right leaning think tank, really truly agrees that we've got to end debanking and remove government reputation regulation. As of this month, federal law still prohibits medical cannabis consumers from purchasing or possessing firearms. There is a Supreme Court case that is scheduled to hear arguments in March, on March 2nd, so right around the corner now. The United States versus Hemani, Hemani. If you want to follow that, it is a landmark case that will determine the federal ban on gun possession for unlawful drug users who violate the Second Amendment. A final decision is expected in the summer of this year. Keep in mind that this is an ATF rule. It is not actually a constitutional rule. The federal gun ban for all Schedule 1 drug users is based on 18 USC 922 G3, which prohibits firearm possession for any unlawful user or addicted to any controlled substance, which technically applies to all controlled substances, Schedules 1 through 5. There is a new ATF proposal in January of this year. The ATF issued an interim final rule that may provide some wiggle room for some cannabis consumers. The proposal aims to redefine what an unlawful user is to focus on regular or compulsive use without a prescription, so that may narrow who is disqualified. And while the Department of Justice has moved to reschedule cannabis from Schedule 1 to 3, the DOJ also maintains that this does not automatically lift the firearm ban. So we are just not there yet. And there's also been a lot of clarifications under this current administration that the federal law will continue to classify marijuana as an illegal substance, meaning any involvement with it can also lead to severe immigration consequences, detention, deportation, denial of citizenship. And because immigration enforcement is handled at the federal level, ICE and Border Patrol do not recognize state legalization. So even if Border Patrol is in California, they do not recognize medical cannabis. All right, the big one, banking and taxes. So the talk of the town and what we really have to make sure we're putting pressure on is around Section 280E of the Internal Revenue Code. This is what applies to any trade or business that consists of trafficking in a controlled substance. That word trafficking is going to be really important because if it's not going through the FDA controlled process, it will be considered trafficking under the federal law. So within the meaning of Schedule 1 and 2 of the Controlled Substances Act, which prohibited by federal law or the law in any state in which this trade is conducted. So because the provision applies only to activities involving substances in Schedule 1 or Schedule 2, we believe that moving marijuana from Schedule 1 to Schedule 3 would then allow cannabis businesses to deduct business expenses on federal tax filings. There are also other legal consequences, collateral consequences, that will continue to attach themselves to unauthorized cannabis-related activities. There is enough wiggle room in the interpretation that you can drive a Mack truck through, which is why we must demand that the interpretation of this includes state legal cannabis businesses, and that we are not just slated towards this Schedule 1 trafficking concept because we are not part of the FDA process. Like any business, a licensed cannabis enterprise is subject to taxation. You've got to pay all your applicable state and local sales taxes, state and local business franchise tax, payroll tax, state corporate income tax, and yes, of course, federal income tax. The IRS, Section 280E of the tax code, has historically applied to cannabis businesses because the federal government considers them to be engaged in trafficking in controlled substances. So when cannabis is moved To Schedule 3, the Congressional Research Report that was released in 2024 believes that cannabis will no longer have the 280E rule apply. The Department of Justice's ongoing review to reschedule cannabis to Schedule 3 is a step towards aligning federal law with scientific evidence and public opinion. But rescheduling is not going to solve the banking crisis that you face all the time, every time you get debanked. The primary barrier to banking is not solely the Schedule 1 status. It is the persistent risk of federal enforcement action under money laundering statutes. It's basically fear. The absence of clear uniform standards, uniform safety signals from federal banking regulators, and even under Schedule 3, cannabis is still a controlled substance, so financial transactions involving cannabis could still be construed as facilitating a federal crime, leaving banks feeling exposed to criminal liability and regulatory sanction. So again, it's not that you can't bank, it's that banks won't. Not that they can't, they won't. And they won't bank you unless you are really in the big money. At the same time, legitimate businesses operating in multi-billion-dollar state legal markets still cannot gain access to financial services like loans and other financial products that any other legitimate business can do. This also could shift. Things like the Small Business Association could potentially start to work with small businesses, but again, it's all about the interpretation. Also, because of the lack of safe banking, we're still dealing in cash, and this is a constant issue for your safety, your employee safety, public safety. You just become a target, and there's just still a lot of evidence that banks are refusing to service even state legal businesses with permits, despite the FinCEN guidance, the financial crimes guidance, way back in 2014. So we really have to have a additional permission structure and clear rules and regs for banks to feel comfortable and get over the fear. And trust me, the fear has been very intentional. So Trump issued the executive order in August, removing the reputational risk standard, which is what, as I mentioned, Operation Choke Point relied on. And I think just placing a simplified bill that reforms this so that it's just not permitted by the next administration would be ideal. Again, an executive order does not and cannot change the fact that cannabis remains a controlled substance under federal law. So without that safe harbor, we also need to direct the Secretary of Treasury, who acts through the Financial Crimes Enforcement Network, that's FinCEN. We need them to issue a new, streamlined Banks Secrecy Act framework. This framework should establish a simplified, you've heard of SAR reports, SAR, suspicious activity reports. For example, compliant cannabis businesses trigger a lot of SARs. And so for account holders fitting within this category, financial institutions should not be required to submit continuing SARs for the same activity over and over again identified within compliant cannabis businesses, unless the financial institution has a true reason to suspect the business is not compliant with state law. So just the act of doing business should not be triggering all these reports. It should also clarify what low-risk categories are, like schools, right? Explicitly stating that bank services to cannabis ancillary service providers does not in itself trigger cannabis-specific SAR filing obligations. You don't have to be touching the plant to get kicked out of your bank. I just lost another account within this last year. And we have been just a school since our federal raid back in 2012. So also we need to instruct federal bank examiners that compliance with the new framework fulfills the BSA obligations and is just not a basis for penalty. We also have to direct the Attorney General to issue formal guidance to U.S. attorneys stating that investigating or prosecuting financial service providers and cannabis businesses for servicing state authorized cannabis businesses or being one, that this is not a department priority, provided they are adhering to this framework. And finally, we have to instruct federal banking regulators, the FDIC, the Federal Reserve, OCC, and CUA, to jointly issue public statements of principles, updating their examination manuals to affirm that providing banking services to compliant state legal cannabis businesses is in compliance with the new DOJ and FinCEN directives, not in and of itself an unsafe or unsound banking practice. So, legislative action, such as strengthening the 10th Amendment through entrusting states 2.0 Act, that's a mouthful. It's also called the States Act. Strengthening the 10th Amendment through entrusting states act remains the optimal and permanent solution. So we believe the administration has substantial executive authority to immediately mitigate some of these risks and make sure the interpretation covers you, by providing clear, coordinated policy direction to the financial, regulatory, and law enforcement agencies under its authority. Now, this is a lot, but I'm trying to provide you a framework on who to talk to about what, because you can complain all day long and shout down the dark hallway or on the internet or on social media, but what you really need to do is direct specific comments to those agencies or individuals who have power over that particular action, and be simple and direct. And there will be this on video so that you can go back and double check. Okay, what do I need to say about banking and to whom? Okay, what do I need to say to Congress again? All right, so let's start with the Trump priorities, especially if you happen to be living in a Republican's district, although most of you probably don't, unless you're living further south. So what we're really talking about is recognizing and improving what President Trump just put forth, and ensure that you are part of that solution. So as the president just ordered and directed the Attorney General to expedite completion of rescheduling, as it told the White House Deputy Chief of Staff for Legislative, Political, and Public Affairs to work with Congress to allow Americans to benefit from access to appropriate full spectrum CBD products while still restricting the sale of products that pose serious health risks, and directing HHS, Health and Human Services, to develop research methods and models to use real-world evidence to improve access to hemp-derived cannabinoid products. There are still important barriers to research that, as I mentioned earlier, have to be removed. And I do want to move this forward to just underline that Schedule 3 is not legalization. We are not there yet. And taking a natural remedy through the FDA process is called developing a botanical drug product. So any natural substance, like an herb or a plant or an extract, that is intended to diagnose, cure, mitigate, treat, or prevent disease, it must be evaluated by the FDA as a drug. It involves rigorous clinical trials, safety testing, and regulatory review under the FDA. This process is not automatic, and once a botanical drug successfully completes, it's got to go through phase 1, phase 2, and 3 trials to meet efficacy and safety standards. It may then receive FDA approval for marketing as a prescription or over-the-counter medication at some point. This is Pfizer territory, and they are lobbying vigorously. There's also a concern that any cannabinoid that is patented by a pharmaceutical company in and of itself then becomes a drug, an adulterant, not an ingredient. And we plan to unpack that in the ramifications of intellectual property, both for you to protect your brand and your outputs, but also what others are doing in competition with you that have millions and billions to spend on it, Pfizer. So we'll unpack the ramifications of that, I believe, March 31st in a future webinar with intellectual property attorneys Dale Hunt and Luke Zimmerman. So moving cannabis from Schedule 1 to 3 without all these other legal changes are not going to bring you, the adult use cannabis industry, nor the state legal medical industry, what little of it is left, into compliance with federal controlled substances laws. With respect to medical cannabis, the key difference between the placement in Schedule 1 and 3, of course, the accepted medical use, but it's all of the approvals that it has to go through. And while some drugs are derived from or related to cannabis, the whole plant medicine itself is not an FDA approved drug. There's just a lot more that's going to happen to obtain FDA approval. So we're going to talk quickly. There is California's Assembly Bill 8. We have a window of opportunity here for reimbursements to happen for CBD only products that you will be allowed to manufacture and carry. The law does say hemp derived, and the emergency California hemp ban passed by Governor Newsom did contemplate this law change to automatically allow for state legal cannabis businesses to integrate products containing concentrated cannabinoids derived from hemp other than CBD isolate into the state's licensed and regulated cannabis supply chain. So aside from the pure CBD isolate, all other products can fall under the definition of a cannabis product and sold through a legal cannabis dispensary. The Senate also amended AB 8 to clarify that cannabinoid products derived exclusively from industrial hemp may be shipped through the state without entering the licensed market. So there may be some transport through the state, provided it's not sold in California or shipped out of California by a licensee. So you still can't participate in interstate as a license. This also aligns with the interstate commerce protections in the 2018 Farm Bill. So it's kind of weaving a very narrow legal thread through the needle there. There is another Senate amendment that provided that until January 1st of 2028, licensed manufacturers of cannabis can only use cannabinoid concentrates and extracts that are manufactured or processed exclusively from cannabis. But then after that, you'll be able to participate with hemp. So we need a hurry up offense on that. And then, and only then, if the prescription exists for that person, will they qualify as a patient for reimbursements. So all of that still feels cloudy. I would recommend that you take a look at some of the lobbying and recent statements by the Stanley brothers, who are producing Charlotte's Web, to understand what their play is here, and that'll help you understand what I'm talking about. So as long as what's commonly known as the Rohrabacher-Farr Amendment remains in effect, only medical state programs are protected by the budget rider. And this is not really going to change for you if it hasn't affected you thus far. We, as adult use providers, were never protected from this. And rescheduling would not actually affect the medical marijuana appropriations rider. So with respect to manufacture, distribution, possession of adult use cannabis, moving into Schedule 3, you're still illegal under federal law. And subject to federal prosecution regardless of the status, which is why I'm also so concerned about how other things are interpreted. So we talked about GMP and GACP. It is common to confuse the two, but it's good manufacturing practices that we are going to spend most of the next few minutes on before we close this out. The two are complementary, but they are applied at different stages of the production process. And the GACP, the agricultural collection processes, what focuses on plant cultivation, harvesting, and that initial storage. So for the most part, what you're focused on is GMP, the processes of the harvested plant and the transformation process, extraction, formulation, packaging, labeling. So GACP is in the field, and GMP happens from the extraction lab all the way through whatever manufacturing process and factory through retail. To operate legally and guarantee a high quality product, both will be essential. And so why I'm mentioning GACP, even though I don't believe we have any cultivators, you are going to need to source your inputs, your materials from a cultivator that follows the good agricultural and collection practices in order for you to follow and adhere to the GMP regulatory regime. The revised guideline has established a principle. The closer a process step is to the finished medicinal product, the more likely it is to follow under GMP versus GACP. So it's just easy to differentiate. And that does matter enormously for cannabis, simply because if the dried cannabis flowers are intended for direct dispensing to patients, like the whole plant medicine, straight to a jar, straight to a patient, their processing is no longer just agricultural. So there is a slight bit of GMP oversight with the qualified person who is responsible. If those flowers are just intermediate for extraction, then that manufacturer has to justify whether or not it's GACP or requires a full spectrum GMP process. This is also what you're going to need to understand to access international markets, because internationally they're only going to accept products that have followed and can illustrate and demonstrate GMP and GACP practices. Now, please do not let this completely freak you out. A lot of you already follow a lot of the principles within these practices. You just have to write it down a lot more often and with consistency to be able to prove it. So different countries have different guidelines. I would recommend that you look up the EU guidelines, because the EU are the money countries that can afford to purchase your products at some point. GACP certification is probably not going to be mandatory for any of you, and not mandatory for state legal cannabis. This is not for the current market that we operate in. This is if you want to cross into. All right. So, like I said, day to day, especially professional farmers who generally they already apply a lot of these practices that are aligned with GACP. We're talking about hygiene, documenting processes, control of each stage of the cultivation, and then, ensure that they're fulfilling the objective of the quality of the cannabis, that there are quality assurance practices. So you just need to find these growers, as I said, and say, show me your GACP practices. GMP is the one that you personally are going to need to execute. These are the regulations for edibles, infused flower, pre-rolls, tablets, tinctures, topicals, vape cartridges, integrated vaporizer carts, all of it. You just have to ensure that these products are free of contaminants, safe for consumers. You already do this. Testing, you already do this. Produced consistently every time. You really try to do this. Labeled correctly, you already do this. So manufacturers, you just simply have to demonstrate your GMPs by establishing and implementing that robust quality control program that you're probably already following, and just write it down and describe how you are complying with the following, and write down who and when and what. So getting into the standards of your interior, exterior, even the grounds around the outside of your manufacturing facility. There are requirements for all of these things: the design, the construction, the installation, cleaning, sanitation. Sound familiar? It's a lot of the same things you already did for the DCC and the DCR. So it sounds like a lot. It sounds like it's not surmountable. It sounds like, oh, good Lord, a whole nother stack of things. But this is how you transition from the state legal market to the international markets and the interstate markets. This is how you grow. This is how you just start thinking about, over the next couple of years, you skate to where the puck will be. All right. The biggest part: documentation, documentation, documentation. You need the product quality plans in place. All right. I'm going to hurry up. We have the criminal penalties that still apply even if we go to Schedule 3. Even if all of these things that I talked about being stuck happen before we have another webinar about it, just please keep in mind that even when cannabis is moved to Schedule 3, the applicable penalties for many of these offenses, while maybe reduced, maybe start changing, maybe reducing the stigma, but a lot of these penalties that apply to activities involving cannabis trafficking specifically, including mandatory minimums, will not change as a result of rescheduling. So we really have to make sure that we are demanding better. And we still have individuals incarcerated to this day. We still have mandatory minimums for even just possession. And there are still tremendous collateral consequences, including child custody and housing. So asset forfeiture is still alive and well, and the government will still be able to seize property if it can prove that it was purchased as a result of violating the Controlled Substances Act. Remember, Schedule 3 is still a controlled substance. So last, I just want to talk again about considerations for Congress, because only Congress can fix it. Regulatory changes cannot fix a broken system. Last week, the FDA just missed another deadline under the new hemp law to publish a list of all the cannabinoids produced by the plant and define what a container is. So we're still taking like baby steps forward, but the new changes to the hemp law recently kind of undid a lot of what we thought we understood to be true. The good news is anytime there is a tremendous shakeup, there is an opportunity for massive momentum, for massive change. So you already know now that Congress has the authority to change the status of cannabis and just skip all of the ridiculousness with the notice and comment rulemaking process with the DEA that we have undertaken multiple times over 50 years now. And the DEA thus far has stated that when it conducts the scheduling proceedings, it has the final authority to schedule, reschedule, or deschedule a drug under the Controlled Substances Act, but so does Congress. So a proposal from this Congress or the next Congress could entirely shift again and unstick this stuck. If Congress decided to change the legal status of adult use cannabis, it has the broad authority to do so before or after the DEA makes any final decisions. And we also have just a few state specific laws and rules that need to be massaged in order for you to take advantage of these new opportunities. So we live in interesting times, and this one is hard, but we do have opportunity here. And more, as I mentioned before, there is a shift towards regulating this as one plant with many uses. And at the end of this year, when we take Aunt Betty's hemp beverages away, Aunt Betty's not going to like that. And she's going to say, why was that taken away? And just might start paying attention to this ridiculousness. And so to rectify the state-federal conflict that currently exists, to ensure that you have some control in a market, that we have a majority of states that have enacted public adult use programs that consider public health and safety, that consider preventing the distribution of cannabis to minors, that try to ensure safe business practices, that this can be considered by Congress and recognized. So you do need to contact your local city council and ask them to lobby Congress. You need to contact your state representative and state senator and ask them to lobby our governor and Congress, and contact your governor and ask him to make sure that California law has defined this hemp ban to more quickly allow state licensed cannabis businesses to participate in this reimbursement opportunity for full spectrum CBD products. And our governor can lobby Congress. He can go on the news. So on behalf of his small businesses and California taxpayers. We can apply pressure from all angles here. Start at congress.gov, because those congressional and lobby actions that you can take in under 10 minutes to call all 6 offices, it's under 2 minutes per office. Trust me, it's fast, it's quick, it's painless. Have a short paragraph that you just read off of on the phone and say thank you. Start with, I am a voter in your district. And you do have strength in numbers. We can push back on large lobby dollars with large voter numbers. It is strength in numbers. So please go forth and conquer. As Margaret Mead said, never doubt, a small group of thoughtful, committed citizens can change the world. And indeed, it is the only thing that ever has. And I have learned that grassroots movements like this one, like you, drive significant social change. It's not the top down. We, the people, are the catalyst for transformation, and we can demand better. We can demand that we are part of this solution. It is worth it. We can do it. Thank you for your time and attention today.
Thank you again, Dale, and for everyone for sticking around for this informative webinar, which is offered by the City of Los Angeles Department of Cannabis Regulation's Social Equity Program. This webinar recording will soon be available on DCR's website, cannabis.lacity.org. If you have any questions on accessing your LMS account, please email dcr.sep@lacity.org. You can still get a professional business coach. This is a consultant dedicated to helping your business succeed. I'm Angela Bacco with Oaksterdam University. We're grateful for your time and attention. Thanks again for joining us today.